Please raise hand. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. We have also received emails from those who have provided written comments on a particular matter. Ready for me to call the roll, Madam Chair?
Yes, ma'am.
Ms. Barnes, are you present?
Barnes is present.
I'm sorry, I didn't hear Ms. Barnes. Are you there?
Yes.
Barnes is present.
Thank you. Ms. Faith?
I am present.
Mr. Donovan?
Present.
Mrs. Johnson?
Present.
Mrs. Johnson, we have a quorum.
Thank you very much. Do we have any postponements or withdrawals?
Yes, we do have two, Madam Chair.
Okay.
First
Yeah.
one is on the screen.
Yes.
Calendar 20-135 is requesting a postponement. That's regarding the 1415 Kenilworth Avenue. This is the second hearing for this case. They are requesting a postponement to the next hearing when we have 5 members. Ms. Britt will be present after November 9th, I believe. So November 16th.
Okay. Without objection, Board, November 16th for the case?
Madam Chair, I just would like to point out an irony of this particular deliberation,
Yes.
and that is that the appellant is asking for any decision to be made by a full complement of the board, and we do not have a full complement today. Just thought I'd point that out.
Thank you. Thank you. I'm ducking in case he's throwing stones.
So do you want me to call the roll, or we're
Please,
doing no
Ms.
objection?
Kukla, you didn't read the,
answering.
Ms. Kukla, you didn't read the first one.
Oh, thank you.
Well, that's the last
So this
one on
is-
the page.
This is regarding calendar number 19. The first one, the first request for postponement is calendar 19-301. This is regarding a parking assessment made to the owner of this property. It's a downtown parking lot, I believe. The appellant is working out an agreement with the city. This request for postponement comes from the city. I believe that they're coming very close to achieving that agreement. So we could push this out to November 9th, the first or second. That would be the second week in November, or we could do the first week in November. Give them a little more time to work out.
If they have it settled, then we can take it off our calendar.
Sounds good,
Objection.
November 9th then, Madam Chair.
Okay. Call the roll on both these.
Thank you, Madam Chair. Ms. Barnes?
Miss Barnes.
Ms. Barnes, any objection? Or are you voting yes?
I have no objection at all.
Thank you. Ms. Faith?
I am without objection to either one.
Thank you. Mr. Donovan?
Without objection.
Mrs. Johnson?
Without objection to both.
Thank you.
Mhm. Okay, we'll go with calendar 20-134 at 4329 Lorraine. Ms. Faith?
Thank you, Madam Chair. Calendar 20-134 at 4329 Lorraine Avenue. AHA Development, OHC, LLC owner proposes to construct a new retail and office building in a D3, a local retail business, and a pedestrian retail overlay district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinance as stated in the agenda and the public record.
Thank you very much. Mr. Donovan?
Everyone for this case, please raise your right hand. Please answer my request with "I do" and your name. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do, James Asimus.
Joel Aubrey.
I do, Matt Moss.
Anyone else?
Don Pettit, you are muted.
I do, Don Pettit. Thank you.
Okay.
Any others? That is it.
Okay. Well, we've had the history of the property. Let's just have the legal standard we'll be judging the case on, please, Ms. Wagner.
Thank you, Madam Chair, members of the board. Appellant is requesting an area variance from the off-street parking requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and the granting the variance not be contrary to the purpose and intent of the zoning code.
Thank you very much. And the spokesperson for AHA Development is?
Madam Chair, I see James Asimus on here. I believe that he is the spokesperson. I'm not sure if he's having some technical difficulties. It looks like his line is still muted.
Yeah, he is
And
still
also-
here.
And also we have a Jeff Sertel. I don't see his name either, but he was identified as a representative of this appellant.
Hello, James Asimus? Let's hear from Donald Pettit first, then. Unmute yourself, Donald. Thank you.
Thank you, Madam Chair. Don Pettit, Secretary of the Cleveland Landmarks Commission. The commission reviewed this last year and approved it. It went through a long design review process. I think it's a better project because of the process. We fully support it now. The changes that have been made to the facade are reflect what the commission asked for. We have no objection to the required variances today.
Thank you very much. Maurice, do we have any renderings or?
Yes, we do.
Okay, I'd like to
I'm
see
just
some.
displaying the support letters at this point, but we can go.
Oh, okay.
And Madam Chair, if I could jump in, this is Liz Kukla again. Just as a reminder, we had testimony, this case was presented to us thoroughly. However, we did not have elevations, and I believe that Ms. Faith requested the postponement in order to allow time for the appellant to return with those elevations, and we have received those today, Madam Chair.
Yes.
Madam Chair, it looks like we also have Councilman McCormick on the meeting.
He has not been sworn in, but we could do that. Councilman?
Councilman, are you there?
Can you hear me?
Yes.
Yes.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay. Well, because James Asimus hasn't answered yet, we'd love to hear from you, Councilman.
Thank you, Madam Chair. Appreciate you having me on this morning and giving me the opportunity to speak. I'm just here to speak in favor of this project, Madam Chair. This property, not at the fault of the current ownership, has been an eyesore in our community for a long time. I got frequent emails from neighborhood residents and phone calls asking when something positive was going to happen on this site. So we're very excited about this project. I mean, it's gone through our community review process supported by our local block club. As Mr. Pettit acknowledged, it's gone through our city processes, and they've worked to make it a great project. So, Madam Chair, currently this is a empty lot on a prominent corner on the Lorraine corridor, which will undergo a large streetscape in a year or so. We'll start kick that off. So this really restores that traditional Lorraine Avenue frontage that makes it such a walkable great corridor for the city of Cleveland. So appreciate the opportunity this morning and just here to fully support this project.
Thank you, Councilman. Oh, and we do have a lot of support letters. Maurice, I'm sorry I stepped on your toes.
No problem. I'm resending an invitation right now for, in case they didn't get it.
I'm sorry, this is James Asimus with the ownership. I may have missed some of the audio then. Are you looking for some feedback or input from me on this?
Yes.
I apologize. My headphones must have cut out at the worst time. What can I answer on this?
Well, at least make a formal little introduction and
Sure.
to address the variances and ask us to approve them.
Sure. And I apologize again. What we're looking for is a variance for the additional parking on the south of Lorraine Court to be considered as part of the parking to satisfy what we'll need for the building north of Lorraine Court and the parking that we have behind it. It's our plan to add additional parking back there, but the plans that we have submitted so far deal with the structure north of Lorraine Court and the parking just behind it. Those 8 spots just behind fail the requirements from the city, and so that's why we are here seeking a variance. We are anxious to get started on construction with this. It was the parking issue was one that we did not anticipate having to come to, and so that's where our urgency comes from with this. We have a tenant in hand that we're pushing to stay in the neighborhood. It's Sherwin-Williams. They've closed their store down the street at the old Market Plaza, and we are providing them a building that'll allow them to stay in the neighborhood for the next, hopefully, 25, 50 years. And that's part of what's pushing our urgency with this as well.
Did you meet with the one neighbor who had given testimony that he wasn't as familiar with the project as he would like to be, given what will be an obvious impact on his property 2 doors down?
The gentleman that was on the last hearing?
Yes.
Yep. Yeah, we presented again to Block Club. Been there. I believe it was last week.
Madam Chair, I have the support letter from the Block Club on the screen at the moment.
Yes, they're in support.
I would also like to point out that Jeff Serto has joined the meeting.
Okay.
Has he been sworn in?
I don't believe so.
Jeff?
Mr. Serto, could you raise your right hand? Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Either a yes or an I do will do right now.
He is muted. He might be having technical problems.
Shake your head up and down.
I don't even see him on my screen.
He doesn't have a video feed right now.
Okay.
We do have Mr. Trimble with his hand raised. I don't know if he was sworn in before.
Jeff, were you sworn in?
Oh, and now we have Jeff Serto with his hand raised.
Hello?
We can hear you.
I do.
You can hear me?
Yes.
Mr. Serto, we're awaiting a response of I do.
I do.
There you go.
Okay.
Knew you could do it.
Had to catch up with the technology.
Yes. What is your position with this group?
So I'm the architect for the project.
Okay.
Been working with the owners on developing the plans and working with the local community groups to incorporate their concerns.
Beautiful.
Okay, so what have you done with the parking spaces? Any changes since the last time we heard this case?
There's been no changes. Since the last case, we've just provided more information to the board.
Don't you have a
So you have a better
parking arrangement
understanding.
with somebody across the street or something?
James might know that.
We do not have a
I'm not
parking
aware of that.
arrangement with anyone across the street. We have parking that we're planning on developing south of Lorraine Court. But that's the extent of it.
Yeah, ultimately there will be more parking south of Lorraine Court, but that will be owned by the same ownership group.
So people have to cross Lorraine then to park?
Lorraine Court, the alley.
Oh,
south.
the alley, okay. I missed. Okay. This is going to be Sharon Williams on the corner?
Yes.
Okay. Okay, board, any questions?
City?
Madam Chair, we have Matt Moss to represent the city today, and we also have Brian Stefan with his hand raised, and Mr. Trimble with their hand raised.
Okay, none of them have been sworn in, as I recall.
Have you all been sworn in?
And Joel Elvery as well.
Okay, anyone who has not been sworn in, we're going to do it. Raise your right hand. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I do is a good response, and your name.
I do.
I do.
Joel Albrecht. I do, Michael Fiala.
Okay, in alphabetical order, let's hear from each one of these gentlemen. The A first.
Well, let's go with Ben Trimble.
Okay, Ben,
Thank you, Madam Chair. Since the last meeting, we worked with the Block Club Chair, Joel Elvery, who is also on the call, to organize a meeting for the developers to address the community, to address any outstanding concerns. That was held last Wednesday, and you can see a letter of support from the Block Club. Just to make sure that all the facts on this case are clear, we have been reviewing this project for over 2 years. It had been quite a while since we went back to the community, so I think that the extra community meeting was warranted. But all the parking actually for the site will be provided. It will just be on an adjacent parcel directly to the south that's owned by the City of Cleveland Land Bank. The developer is contractually required to provide that parking. We worked with the city planning department to try to provide that parking as district parking so that it could be available to other people at peak times, because as many folks on the board here know, that parking will not be fully occupied at all times. So this would be able to service the needs of other users along the corridor. Like most sites on Lorraine, there is not parking on site, but most other buildings do not actually have the ability to provide it. The building that the developers tore down just a couple months ago that was condemned and whose roof was collapsing on itself had exactly 0 legal parking spaces associated with it. So they're providing an infinite amount more parking than was that was provided for the building before. It has been supported by the Block Club, has also been reviewed by the Ohio City Design Review Committee. Thank you very much.
thank you, Ben.
And then with the Block Club, we have Joel.
Joel, go right ahead.
Thank you very much. I just wanted to say a couple things. So I think my letter, I wanted to be clear about my letter. I think it was a little bit unclear about support versus not support. So the Block Club as a whole supported. I would say there are 3 people at the meeting who did not support the variance. And overall, the Block Club had a concern about just the fact that we're having to review this one phase separate from the others. And you can see the issue in the conversation that you've had so far today, and that this concern about parking, obviously the parking is coming from another lot. but the plans for those lots for the next two phases of this project haven't been finalized. So we're, essentially having to trust. The reason, and the block club, we basically supported on the condition that we could see some sort of evidence of the parking arrangement, with basically the requirement they provide additional parking with the city, and they were able to provide me with the letter, the agreement with the city about the land bank lots, which shows that they require 18 spaces of district parking. And my understanding is there'll be more than 18 spaces in that parking lot, but it is frustrating to consider such a large project piecemeal. But unfortunately, that's sometimes how the cookie crumbles. But I do want to express the fact that people were concerned about that facet of the process.
Okay, thank you very much.
We have Brian.
Yoo-hoo.
Hello, this is Brian from the Catholic Worker. We have a community center in that 4200 block of Lorraine, and I also personally have a residence on Apple Avenue south of the proposed building. We've outlined our concerns about the increasing scarcity of parking on Lorraine already, so I won't go into any detail about that, except that one thing we outlined in our letter to the city on October 2nd was that we would request that the developer or Ohio City Incorporated or both speak with the Spanish American Committee that's at the southwest corner of Lorraine and 44th, because of their programming. They often use parking on West 44th, and when they have large parking, they have a lot of pressure to be able to accommodate all the participants and clients at their place. A couple other concerns about the parking is the renters for the retail space and for the office space that are being courted. We do understand that Sherwin-Williams will likely be coming into this building. By definition, that is not a pedestrian kind of retail business. People don't go into a paint shop and walk out with gallons of paint and get on the bus or on their bicycle. So by definition, those customers would need parking. And then another renter that was presented to us as a potential, if not probable, renter by the representative of the development company is the Social Security Administration. And the representative of the developer at our block club told us that they currently have 20 employees. So that would be a lot of parking needed right there. Our biggest concern is really the block clubs, in that we have not seen a full plan. We hear ideas of maybe 18 parking spaces in the lot or adjoining lots between Lorraine Court and Apple. But we're also told that there will be townhomes. And when specifically asked by a member of our block club, the representative of the developer could not answer exactly how many townhomes, exactly whether there will be parking designated for the townhomes, whether there would be one space or two parking spaces per townhome. So all of this is just up in the air. And then and I'll end with this last concern, is the property at 4308 Lorraine Court, which is currently a residence of someone who's lived there for several decades. And on the design sketches that we've seen so far, her house is no longer there, and it's paved over with parking spaces. And so we're just concerned about the process of how she's being engaged in this overall plan. And I'll leave it there.
Thank you very much. Let's see if we can get an answer to that question.
Yes, this is James Asimus with AHA Development. We've been working with the resident there. I'll respond kind of in reflex to the list just discussed. We've been working with the resident there on acquiring that house, relocating the residents to something adequate nearby, and it's an ongoing process with them. Furthermore, I mean, just to reiterate what Mr. Trimble mentioned earlier, the building that was on this site had absolutely zero parking with it, and there will be additional demand coming for new businesses coming into the neighborhood. It's a natural part of bringing in new businesses in there, and so I think the issues brought up by the gentleman that just spoke aren't unique to this project, but rather benefit that comes with any kind of new construction or redevelopment or any kind of new business coming into an area.
All right, so we can all rest easy that that woman will be relocated?
We've been working with with OCI on what resources are available. The councilman's been helpful in this as well. We've been as forthcoming and transparent with that resident as possible, because we don't intend to just displace them for this at all. And so it's not something where we're trying to pull the wool over her eyes or anything of the sort.
Okay.
Madam Chair, we still hear from Matt Moss with the city's position.
Matt, welcome. Matt?
Thank you, Madam Chair. My name is Matt Moss. I'm the neighborhood planner with the Cleveland City Planning Commission. So I can just speak briefly to how this project fits into some of the longer term planning projects that were brought up. I think Ben did a good job giving an overview of how this project fits into the neighborhood, but like Mr. Asmus mentioned, and I think stated at the beginning of the hearing, we've been working with this developer for quite a while to not only figure out the best use of their parcel on Lorraine, but to incorporate some vacant land bank land to the south, as you can see on the site plan. So that would be south of Lorraine Court and also along Apple Avenue. There's a mix of land bank and private land in there. And so I think we've been working with them to balance all of these concerns in terms of what the code says in terms of parking, to what the actual needs are in the community and for this specific project. And so again, overall, we're trying to fit in redevelopment here to match our long-term goals for Lorraine, to turn it into more of a multimodal corridor. That is currently underway. The planning for Lorraine Avenue and the cycle track specifically is not finalized, but the goal is to again balance the redesign of that street, the reinvestment into that street, along with the system redesign, comprehensive system redesign the RTA has been undertaking, in addition to balancing the existing primary mode of transportation, which is driving and parking as a result of that. So we are working at balancing what proportion of land is still reserved for parking versus what is used for other modes. And I think this project is achieving that balance in terms of reinvesting into the built environment, building up again vacant land, while also providing off-street parking in a way that we've worked with the developer to be flexible, right? So it's parking that's available for anyone wishing to drive and patronize any of these stores or visit the area. And so we're trying to use parking here that's being built on public land to be as flexible as possible, because we understand that the needs for people, not only the needs, but the desire to use different modes to travel around the city is evolving and changing. And so that is why I think to the specific variance requested today, we are working with the developer, like I said, to provide city land bank land that they can build parking on. And the reason why it's not perhaps fully parked as it possibly could is because we still desire, and we've been working with, and the developer still desires to fill in some of that frontage along West 44th. We don't want it built all the way up to the street because it makes it harder to walk, it makes it less convenient to walk, and it makes it less desirable to walk and to bike. So we're striking that balance here. The parking will be provided in the future phase. As mentioned earlier, it's not perhaps the ideal way, but it's the way we have to incrementally develop these blocks in the city of Cleveland. So I think the parking variance is specific to just how our code works today. As you can see from the site plan that was shown earlier, there will be parking provided, and we are working with the developer to figure out the best way to do that. By we, I mean planning, the CDC, Ohio City Incorporated, and community development. So I think it's a comprehensive effort. It's a collaborative effort to try to make sure that we're striking the right balance here. And I'm happy to answer any questions as that relates to, like I said, our long-term planning goals for the city and this part of the city.
Board, any questions?
Looks like we have Alana.
Madam Chair, I have a couple questions.
Go ahead.
With regard to West 44th Street, is that one way? Is West 44th one way, and if so, which direction?
Yes.
North, it heads north. I'm sorry, one way south. One way south.
One way south, okay. So the loading zone is on the West 44th side of the building, and there's 5 parking spaces there. Is that correct? Are the parking spaces clear of that loading zone?
Where is the loading dock? I don't.
It's on West 44th on the side.
Oh, yeah, I see loading zone. Yeah, I see it.
Right, and then there's 5-car parking.
Madam Chair, to Alana, or to the developer, is the loading zone intended for customers, or is that a loading zone as far as making deliveries?
It's a loading zone for Sherwin-Williams and for deliveries for the building tenants. It's not intended to be used frequently. Specifically, Sherwin-Williams receives shipments on a once-a-week basis. So it's very infrequent, but the logistics of fitting any kind of loading off of a large vehicle, semi-truck, anywhere else is too much of a challenge. And so that's one of the things that we were working with planning and OCI on finding a way to accommodate all of that in there. But again, the design of the building and of the tenant spaces specifically allow for the loading and unloading and things like that to happen on the inside portion of the building that's marked as the 8-car parking.
So to the appellant, is the loading zone, is there going to be a curb cut there? Are they going to be able to run a pallet jack or a telemotor in and out of that without a curb?
I believe there's already a curb cut there based on how the previous building had access in and out of the site. There was an existing garage door there. Can we, Maurice, would you be able to scroll to a different, let's see, where are they? If you'll look on these elevations.
Sorry. I was checking to see if I had an actual picture of that side of the site, but I'm not sure.
See the garage door there that they'll access in and out of.
Right.
Yes.
And you believe that the garage door that's in plan aligns with the previous opening from the building that was demolished, right?
Yes, I'm looking through these pictures now as Maurice goes through them.
Okay.
You can see the bollards in the lower right picture.
Okay.
Where they used to enter the site.
Okay. So, and that utility pole still exists there?
Yes.
One, yeah, okay.
It was as
So
of September 15th.
It's still there.
When you took the pictures, okay.
Yeah.
So you don't feel like you need any indentation in the sidewalk there in addition to the curb cut?
No.
I'm just wanting to make sure that we're not going to be interrupting traffic and we're not going to be, we're not going to have a truck in the parking spaces. So those parking spaces are not available.
No,
Because that's going to be a popular spot for Sherwin-Williams.
No, one of the things we wanted to work with planning on, and they were very helpful in working through this, was on what the circulation was going to be for customers coming in from different modes. And so we were very sensitive to how that was laid out on the site to make sure that it was accommodating to everyone, but also done in a safe approach, that we weren't creating more issues with how this was laid out.
All right. I'm ready to make a motion, Madam Chair.
Are there any other questions, board members? If not, go right ahead, Alana.
Okay, thank you. Madam Chair, I'd like to thank the appellant and all the stakeholders and parties involved for coming back to us with a full petition and going back to the community and reaching out to them again, given that it was 2 years since they talked to them last, and for also bringing in the support of the councilman, city planning, the block club, and the development. With all that support involved and the answers to the questions, we're in good faith going to expect them to take care of the neighbor that is going to be displaced by future parking lots, and that they'll work well with it, that the future expansion plan is going to go smoothly. And with that, I move that we approve this variance.
Second.
Call the roll.
Barnes,
Second, Ms. Barnes.
Mr. Donovan,
Yes.
Ms. Faith,
Yes.
Mrs. Johnson.
Yes.
I'm sorry, I didn't hear Mrs. Johnson.
Yes.
Calendar 20-134 is granted. It'll be ratified next week, and we will send you a letter.
Thank you.
Thank you, everyone.
Okay.
Thank you.
Okay. And now for the last case, 20-60, the appeal of landmarks. Go ahead, Ms. Faith.
Thank you, Madam Chair. Calendar number 20-60, appeal of landmarks decision regarding 2885 Detroit Avenue, Saucy Brew Works. Me Too LLC owner and Saucy Brew Works leasee appeal under the authority of Section 76-6B of the Charter of the City of Cleveland and Section 329.02D of the Cleveland Codified Ordinances from the decision of the City of Cleveland Landmarks Commission rendered September 12, 2020, to deny a certificate of appropriateness sought by Saucy Brew Works to erect an awning at 2885 Detroit Avenue, filed March 24th, 2020.
Thank you very much. Mr. Donovan?
Everyone for this case, kindly raise your right hand. I'm going to make a statement. Your response is, I do, with your name. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do.
I do, Tom Vanover.
I do, Kerry McCormack.
I do, Fred Bidwell.
I do, Donald Pettit.
Thank you.
Okay, seems like we have everyone.
Okay, great. History of the property, please, Mrs. Cooper.
Madam Chair, this is an administrative appeal. Therefore, we do not have history on this. I believe Secretary Pettit will have a thorough timeline and history on this for you.
Okay. Do I need the legal standard then? Go ahead, Ms. Wagner.
Yes. Thank you, Madam Chair, members of the board. Appellant is appealing an administrative decision. The standard that will need to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
Thank you very much. Well, good morning, everybody. Who's representing Me Too LLC?
Morning, Madam Chair. My name is Daryl Clay, and I'm the attorney representing both Me Too and Saucy Brew Works.
Okay, Mr. Clay.
And I'll be on the call as well. Brent Zimmerman, owner of, as well as Me Too LLC.
Okay, thank you very much. Okay, go ahead, Mr. Clay. Then are you going to be the spokesperson?
Yes, Madam Chair, members of the board, good morning.
Good morning.
My name is Daryl Clay, and as you know, I represent the appellants Me Too LLC and Saucy Brew Works LLC, and also present is Mr. Zimmerman, Brent Zimmerman, who is a principal of Saucy Brew Works. Saucy is located in a building at the intersection of Detroit Avenue and West 29th Street. The address is 2885 Detroit Avenue, and Me Too LLC owns the building. Saucy Brew Works respectfully appeals the Landmark Commission's decision to deny a certificate of appropriateness for an awning that is erected on the west side of the building. So that is extending down West 29th. The awning is made out of black sunbrella fabric. It rests on a painted black frame with a 12-foot double front bar. It's approximately 100 feet wide or long, that is the portion extending down West 29th, and it projects out from the building 8 feet, approximately 8 feet, and it has a 4-foot 2-inch wall rise. Exhibit A is several photographs depicting the current structure of the building. As you can see right there, that is from the southern end looking north down West 29th. Exhibit B, which was also attached to the application, features a drawing of the awning structure, that is how it is affixed to the building. Although the Landmark Commission concluded the awning adversely affected a significant historical or aesthetic feature of the property and is inappropriate and inconsistent with the spirit and purposes of the Landmarks Commission chapter of the city's codified ordinances, we believe that in fact the decision was based on other considerations that are not supported by the record. And accordingly, we believe the decision is illegal, arbitrary, capricious, unreasonable, not supported by the preponderance of the substantial, credible, and probative evidence. And accordingly, this board should overturn that decision.
Okay, somebody's phone has to get muted, Maurice. I'm getting a lot of feedback from somebody's phone. Okay. I'd like to hear from Tom Vanover, City of Cleveland.
Good morning, Madam Chair. How are you?
We're good, thank you, Tom. You're good.
I was invited to the meeting. As you're aware, I don't normally attend Board of Zoning Appeals meetings. But I have had opportunity to be involved with this particular project and the particular awning. For the most part, I don't have an opinion on the aesthetics of these items. As you're aware, I'm more process, and as the building official, the construction of items like this. And I think that the appellate will agree that there's been some missteps along the way for this particular awning. I am less concerned about what the awning looks like at the end than I am that the process has gone, that it's gone through the process of getting the proper approvals. And Mr. Zimmerman and his counsel can explain those missteps along the way. Ultimately, something was approved. I believe that's the picture we have up. And he contracted it, at least And I've had extensive conversation with Mr. Zimmerman regarding this issue as well. This was approved. I believe this is the design that was originally approved by the Landmarks Commission for the renovation of the building. And then when it was finally erected, it was what is the newer awning that doesn't exactly match what we're looking at here. So the Department of Building and Housing got involved, and I believe there's still a open violation notice simply because one thing was approved, another thing was constructed. Ultimately, the board can determine why Landmarks disapproved that design as opposed to this one here. But I will speak to something that's a different part of what I'm doing these days. And that's regarding outdoor dining result pandemic, and as a result to the times we're in these days now. For the record, this was done pre-corona. I think this was all done pre-corona, but the reality of where we are now is
we lost it. Tom, we've lost you. You're breaking up.
Bear with me. Is that better?
Yes.
Yes.
Yeah, my computer was telling me I needed to update. So, all right, I apologize for that. So I spend a lot of my time these days approving dining and exterior dining, and I know that, and I'll just for transparency, the Department of Building and Housing was not happy with the awning that went up because it didn't exactly match what was approved. I have received several complaints from, well, I guess complaints is not the correct word, but several communications from folks that this is not what was approved, with very little communication about whether or not this meets the need, meets the purpose, or is even attractive. I think that a lot of the conversation was, and has been, that I've received, I know, a lot of the conversation that I've received has been surrounded the fact, not of what this particular awning looks like, but around, and I don't know the details, around the tenancy of the building. Apparently there was supposed to be multiple tenants in the building, and local tenants and local companies, startups that are renting space in the building, and some concern that but what I'm being communicated is apparently it's a chain of some sort. I've never title boxing before, but I don't think I've had anybody that's communicated to me that's actually addressed the awning itself. I think it's more of these other issues. And again, Mr. Zimmerman and his counsel can explain that. But I will tell you that we are in the process in the citywide of approving, and the councilman can also attest to that. We're of approving dining, outdoor patios, and we have been basically our mandate is to be creative in doing this. We're issuing outdoor dining plazas for parking lots across the street or somewhat adjacent to the property, and the Ohio Department of Liquor Control has also loosened their requirements to allow people more leeway for this purpose. So this is happening. This kind of thing is happening over the city. This is the only patio that Saucy. So I'll just close in saying I don't have an opinion on what the awning looks like. That's not my job. That's not what I do. That's what you folks do. Thankfully to me, but
Tom, you broke up.
And we the actors, the meeting itself. And then we were disappointed as well at the department because of receiving all of these complaints that this wasn't what was originally approved.
Right.
Since then, Saucy has made application, they've gone through and they've satisfied the process that we require, which makes me happy because that's what I'm most concerned with. And that's what brings us to where we are today.
Thank you, Tom. Appreciate it. Go back to work. Okay, we'd like to hear from, well, the attorney, Mr. Clay.
Let's hear from Don Pettit.
Okay. Don, are you with us?
Yes, thank you, Madam Chair.
I'll go back to you, Mr. Clay. Go ahead, Don.
We have a presentation just to bring the board up to speed on how we got here. And Mr. Vanover has gone through most of it already, so I'll go through this very quickly. We approved this project back in 2016. It's the conversion of an old industrial building in the Ohio City Historic District. It was constructed in 1956, and it was converted into the brew pub and pizzeria that it is today. Maurice, if you can go to the next slide. In 2017, we approved a signage package and an awning proposal. If you go to the next slide, Maurice, the signs were approved. That's just the details showing the original proposal, which was retractable awnings. The signs were approved. The awning went up at the same time that the signage did, but there was no permit, and obviously the awning deviated from what the commission had approved originally. Maurice, if you click through the next 5 slides, those are just the existing conditions, at least the conditions a year ago when we reviewed this at the commission. And that slide just shows you the outdoor enclosure, which was also put up in 2018 and again in 2019. If you go to the next slide, in 2019, permits were applied for by the applicant. We had to review this retroactively. It's always difficult when we have to approve projects after the fact. It went to the Ohio City Design Review Committee, our local advisory body. They recommended approval of the awning, but they did comment that the scale was too much. The commission reviewed it on September 12th, and we denied the application for the awning because the commission felt that it deviated from the original plans, that it's inappropriate because the size and the scale of the awning is disproportionate to the facade and does not respect the rhythmic patterns of the bays per the original approval, and we denied the certificate of appropriateness. I would just like to point out that we're a design review body, and those are all legitimate design criteria per our charge to determine whether changes to buildings and buildings in historic districts are appropriate to their character. The commission expressed its willingness to work with the applicant to explore options to modify or redesign the awning. It was the suggestion of Landmark staff. They might look at it as an art project, that maybe by exploring options for lighting or color or graphics, that it might meet the conditions objection to the awning. Those were submitted by the applicant, and the commission reviewed them and basically turned them down because they didn't feel that it addressed the basic issues they had with the sign, which was the scale and the size. So that's why we're here today. This is not a variance request. There's an objection to our denial of the permit. If you go to the next slide, I just want to point out that this went to the Board of Building Standards in March. They remanded the appeal for the variance. I'm sorry, the violation notice back to the Department of Building and Housing, and they turned down the outdoor enclosure. So that's why we're here today, to determine if the commission did its job, and I guess to find some way to move forward.
Madam Chair,
Yes, who's this?
Tim Donovan. I think it would be appropriate now to ask the appellant to specifically deal with the issues of arbitrary, capricious, etc., knowing and understanding that we've gotten a review of the timeline and the critical path that this project had taken to this date and time.
Thank you, Tim. Okay, let's hear from Mr. Zimmerman.
Or Vanover.
Or Mr. Clay. Hello.
Madam Chair, this is Daryl Clay. Thank you.
Madam Chair, this is Brent Zimmerman. I think it's important that you hear the timeline from me before Daryl moves in as well. Just so the confusion at what was approved versus what was built, how it happened, etc. Is that good with you guys?
Sure.
And so what Don's testimony is definitely true. There was originally 3 awnings that were approved. However, if we take a step back, at the time of the project, we hired Pass Off Commercial Real Estate to help us fill the tenancy of the building. At the time, we were considering between 3 and 4 different tenants to fill the building, and we spoke to over 50 applicants. We actually went to LOI with 3 different applicants, and spent dollars on getting to a legally binding agreement. And those applicants ended up not having the business plan nor financial wherewithal to be able to execute. Furthermore, the bank had said to me, if you want to underwrite clothing businesses, it's be my guest, but you're going to have to come up with more cash to get this deal done. And it was already stretched the amount of money we were putting into, renovating this building. At that point, we did have Title Boxing come to the forefront, and a gentleman that owns, I think, 7 or 8 other Title Boxings in the Cleveland area, who born and bred, grew up in Cleveland, loved the neighborhood and wanted to sign a lease there, which, solved a little bit of our issue. If Steve were on the call, he could probably tell you, but I think we had, kind of this out to the public to fill tenancy for 6 to 12 months. It was through all of construction and then some. As we know, in Cleveland, the retail environment even then isn't necessarily robust. We have a lot of empty storefronts. So I had to make the determination along with my investors to move forward. While I'll agree with both Mr. Pettit and Vanover, we screwed the process up. There's no doubt about that. And I'll take total blame for that. However, I did hire a third-party awning company that I relied on doing their job correctly. I didn't think that when we changed what the awning would be, that they wouldn't go through the process to getting it approved. And that didn't happen. And I'll take full responsibility for that. That's still my fault. However, I don't build awnings for a living. I'll just mention that, and never have. And so, that's how it came to be. I didn't even realize there was an issue for months, maybe even a year after, when we had our temporary occupancy, that this was going to become a huge issue that it has become. The last thing I'll say before turning it over to Daryl, this patio is very important to our business. There are a lot of people that have enjoyed a lot of time on that patio, now more so than ever. Yes, we built this before COVID. Now it's imperative. shutting this patio down would close our business. And we're not really interested in being part of the 40% that will this year. And so I guess it's a little bit asking for forgiveness, and we did make mistakes, but there was nothing that we were trying to do to avert the system or just no ill intentions toward it whatsoever. Whether you like the aesthetics or not, it fits in well with the building and it does its job. It keeps people dry and it keeps people safe, socially distanced, and people are very comfortable being in our patio, and it's been full all summer long. And we hope that to continue into the fall and winter. And I'll turn it over to Daryl.
I have a question, Mr. Zimmerman, before I call on Mr. Clay. I mean, you didn't notice that the thing was going in one long thing and not three separate, and it was going in a different color than the red?
It's not that I didn't know. When you're doing what this building was, as well as starting a business at the same time, so I own the building and the business, there's 1,000 different things going on at once. And especially when you're getting towards the end of it, there's 25, 30, 40 people a day at that place. And I just wasn't paying attention to it. I didn't think about, like, back in whatever date it was that we had separate awnings, and then therefore now this awning is happening. And what I didn't think about is that the team that we hired to do it didn't do their job. I didn't know that I had to handhold the person to go back to the city, to be able to do what we did.
I'd like to know who they are. I'd like to take them off the list of qualified contractors for the city.
I'll get you who they are.
Okay, thank you. All right, now we'll talk to Mr. Clay.
Madam Chair, thank you. In reviewing the matter, I think you've heard from Mr. Vanover that there haven't been complaints about the aesthetics. I believe the councilman will also tell you that he supports this structure. The bases that Landmarks has cited is, as I was trying to quickly read what was up, the size and scale of the awning is disproportionate to the facade and does not respect the rhythmic patterns of the bays. I think you have to take a kind of a step back and look at this from 30,000 feet. The size and scale of the awning, the overhang itself is the same as what was approved in the original design element. There are really two principal deviations. One is the color, and Mr. Zimmerman has addressed, kind of, he was under the belief that all the proper permits and approvals have been secured. The second deviation is that rather than it being three discontinuous awnings, it's one single continuous awning. And I saw the Block Club objection was that having the single awning somehow disrupted the flow of pedestrian traffic up and down West 29th. I have a hard time understanding how one single protrusion on the sidewalk is somehow worse than three separate protrusions. Had it been constructed in that way, you'd have, one bay and then a sidewalk area, but no one would walk into that area of the sidewalk because they would be between two bays. So again, I think it's a question of elevating a little bit of respectfully form over substance in saying it disrespects the rhythmic pattern of the bays. I think this is achieves its intended purpose. And frankly, one of the photos that we introduced into evidence, I haven't seen it shown up here yet, but as opposed to the picture that is here right now, which shows the building to the east of this one that was under construction, now that it's been completed, that building is primarily gray and white. And so the selection of the black awning color actually, I think, turns out to be precipitously good because it blends in much more than a large, whether it's one or three red awnings. Mr. Zimmerman has described for you the importance, that, of course, that the awning has. I believe he would also tell you, if given a chance, that when the design was undertaken, that there was no effort to disregard the historical aesthetic of the neighborhood, that the renovation of the building was conducted with that in mind. And to sharpen a point that he made, I believe part of the reason for the original three bays was the anticipation that there were going to be multiple first floor retail tenants, in which case it would have made sense to have separate awnings. When they had to pivot and go to one principal ground floor occupant, that design didn't make as much sense, and now we have the single awning here. So again, in terms of detraction from the neighborhood, we've offered in our Exhibit 5 multiple letters of support representing not just single individuals in the neighborhood, but owners of multiple businesses employing hundreds of people. Saucy itself employs 50 people. It's very active in the community. Our Exhibit 6 talks about its contributions to the community. I think it would be appropriate to hear from Councilman McCormick. I know he was on earlier. I think he's still on, but I do believe that he would indicate he supports the awning remaining in place.
Thank you. Maurice, is Councilman Councilman McCormick still with us?
Looks like he is, Madam Chair. Councilman?
Councilman McCormick?
Hi there. Can you hear me?
Yes.
I'm trying to be a good muter so I don't disrupt the meeting. Thank you, Madam Chair. I appreciate the time to again speak here today as well on this matter. So, Madam Chair, this was brought to my attention. I don't know, maybe a year or so ago. Time just kind of all blends together now. And what we did is we immediately convened the groups, both Mr. Zimmerman and his architects, as well as the Landmark staff, to try to work together towards a resolution for this matter. And we're speaking pre-COVID for the moment. As is my style, I always try to bring people together to see if we can, use common sense and work together and find some sort of resolution. And so we put a lot of good faith effort into doing that, into bringing in the parties to try to work things out. Once some solutions were put forth, those were then denied by the commission. So I just wanted to first put on record that we really did try to convene all parties, to make adjustments, to come to a resolution. And so that really, that good faith effort was put in, which included Landmark staff and others, to try to work this out so that it, quite frankly, wouldn't have to come in front of you today. So that effort was put in, but after that work, after some of those changes were proposed, it was still denied by the commission. And so I just wanted to first make that note. Madam Chair, I just from a business perspective, I don't know if it has anything to do with what's in front of you today. I've got problem businesses in my ward that give me headaches every weekend. This is not one of them. They have been a upstanding business in our community, and as has been noted in prior conversations, I am very worried, very, very worried about the local small businesses in our community and what's going to happen through COVID. So as Commissioner Vanover kind of alluded to earlier, he and I have been working together quite a bit to do whatever we can, Madam Chair, to save our small businesses, which is not, only an issue here in Cleveland, it's an issue nationally, but we're trying to do whatever we can to save our local small businesses to ensure that we keep as many of them, quite frankly, as we can. So, again, this is a good business, a small business in our community. I don't get loud music, crazy crowd, all these other complaints that we've seen from other places. I don't get from here. This is a high quality small business. And as I did before, I would hope that something can be worked out here. I do not want by any means the city to put out an order that they have to tear off this entire structure of their building in the middle of a pandemic, when outdoor seating is not only much safer for your health, but is so important to our small businesses. I don't think, quite frankly, Madam Chair, that's where the city should be spending its time right now. Again, as Commissioner Vanover noted, he's been working so hard to keep businesses afloat by being creative and innovative about expanding seating for our small businesses, so that they can do so safely. So I just, again, wanted to note that we really worked to try to work this out in advance. Unfortunately, that was not successful when it went in front of the commission. That this business is not a problem business for me at all. This is a quality small business, and that and also identifying, as they've admitted, Madam Chair, that they, did not go through the correct process on the front end. I want to make sure that, I'm happy that they, acknowledge that as well. But again, I would hope as a city that we're thinking creatively about how do we support our local small businesses? How do we expand seating so that next summer they're still around? So, Madam Chair, I hope that we can work in that light. And I really, really hope that this does not get to a point where the city's ordering any forced removal or anything like that. I think that would be counter to the good work that the city is doing to try to support our local small businesses. Thank you.
Thank you, Councilman. Get the trees trimmed all over the city.
You got it. Yeah, absolutely.
Thank you. Okay. Was there one more person, Maurice, sworn in?
We do have Mr. Trimble.
Okay. Ben, are you still with us?
Madam Chair, I am, yes.
Okay. Then your comments?
So our organization has not taken an official position, but this was reviewed by the local Ohio City Design Review Committee, and it was approved. Understandably that there was some difficulty in the permitting process here, but was reviewed by the local design review body and was approved there.
What was approved? The original design or
the revised design also?
Okay.
Okay. So we got a black full-length design on the street.
No, Madam Chair, what we have is a question of whether or not the Landmarks Commission was arbitrary, capricious, unsupported by the facts in the deliberation and the recommendation that they came up with. I mean,
Absolutely.
It's interesting, this body, although we're hopefully most known for having to review and either approve or disapprove variances, we end up with things like this on our plate as well. And this seems to be a question that should be seeking a variance, in my mind, but that's not the question before us today. The question before us today is whether or not the City of Cleveland's Landmarks Commission view of and determination of this particular situation. And I have not heard testimony. In fact, I think I've heard testimony, and rightfully so, and thank the owner for admitting that, hey, okay, there's a ball dropped here. It was our ball. We dropped it. Had we known more, we probably wouldn't have ended up in the situation we are. By the way, I also think I heard enough testimony for people to say that they do want the resolution to come about that doesn't hurt the business, that does provide outdoor dining, etc. So my question gets to be, after the ruling that we make on the arbitrary capricious issue, as to whether or not Landmarks, and Don, you'll know this hopefully better than anyone else, whether there's still an opportunity to get everybody together and find the compromise that is so needily sought for this particular situation.
Any other comments, board?
Madam Chair, this is Lori Wagner. Could I make a comment?
Yeah, absolutely.
I've been thinking through the procedural aspects of this, and I think in this case, you're asking less whether the board was arbitrary and capricious, rather to make a determination as to whether the evidence supports the decision. And the distinction there is, I'm not sure they could apply for a variance afterwards if the board affirms that decision. I mean, you're really reviewing the whole decision and the evidence that supports or does not support it. So I don't know if Mr. Clay has any comments on that.
Hello.
Thank you. I was unmuting. I think in light of what you have heard today, that there have been really no complaints about the awning as constructed, but rather there was concern, and this was evidenced in the minutes of the Landmarks Commission meeting. There seemed to be an equal, if not disproportionate, amount of concern relative to adherence to the process. And Mr. Zimmerman has acknowledged for you that the process wasn't followed properly. Understanding that, as we sit here today, is it legal, reasonable, and appropriate for this awning to remain in place? I mean, it would seem a great exercise in futility to be ordered to take down an awning, which is the natural result if the commission, if the board upholds the commission. Have to take down this awning and then have to go back and re-permit it when the design as constructed hasn't precipitated complaints within the neighborhood. So again, we think it is appropriate. We think that the decision that Landmarks reached was not supported by evidence before the Landmarks Commission. And as a result, that makes the determination arbitrary and capricious and unreasonable. And for that reason, again, we would ask the board to overturn the Landmarks Commission's decision and order the certificate of appropriateness to be granted.
Going to go to Donald Pettit now. I'd like to have some comments.
Madam Chair.
Yes.
Before we call Don, I have a question. Are we trying to hear that they did wrong and they wanted to say that they didn't do wrong, or what are we going with this? Because to me, you had a plan, and what do you want us to do? You didn't go by the plan. So what point here do you want?
Madam Chair?
Madam Chairman, it's Tom Banner, if I may.
Yes, Tom.
That's a great point and a great question. And just because I'm the one responsible for determining wrong when they did wrong, we did cite them for work without a permit. The Board of Building Standards upheld that violation notice, and they were, they upheld the violation notice. The applicant then made application to through us for the new design. So I don't think that where we are right now is that they did wrong and they're trying to say they didn't do wrong. They had an approval. It would really, just for context, it would be no different than if they had originally installed the red awnings for 3 tenants, and then Saucy ended up taking over the rest of the tenant spaces and came back to put up 1 awning. And I think that's, from my experience, and again, the determination of arbitrary, capricious, and contrary to law is not something that I have the authority or even the intelligence to speak on. But once they came back to make application to us, they had then did right after they had done wrong. But I still think that that's a lot of the complaints that I'm receiving. That's what people are telling me is not where we are in the process now, but that's not what we approved. I think at this point, everybody's agreed that that's not what was approved, but now it's just a matter of, is there ever a path to getting anything else ever approved by the Landmarks Commission and of course, the locals that are upset about it. So I hope that answers your question.
Thanks, Tom.
Madam Chair, Madam Chair, this is Liz Kukla. This question is to Lori Wagner. Does the board have the ability to acknowledge that, or to state that Landmarks Commission was not arbitrary or capricious in their decision to deny because they followed their guidelines? But can we also, in that same motion, state that we don't, or that the board doesn't find that there's evidence to support that decision and vote approval for this? Is that something that they could sort of split hairs on to Lori?
Ms. Wagner. Ms. Wagner, are you with us?
She's moving.
Actually,
I don't see her participants anymore.
Actually, yeah, she's not. I think we lost her.
She ran out the door.
Don Pettit?
You're not, see, Lori Wagner is not on anymore.
Don Pettit still on?
Don Pettit is still on?
Okay, then I would like to hear from Don Pettit.
Thank you. Thank you, Madam Chair. I'm not going to argue aesthetics with the counsel for the appellant. I don't think that would get us anywhere. But I do think that the objections the commission raised transcend aesthetics and were legitimate concerns. I do think there was a problem with the process, but I'm not here to point fingers. I'm not here because, we want to blame the applicant, the appellant, for what's happened in the past. I want to point out that the commission supports outdoor patios everywhere in our historic districts, and we support this one. We've approved this one. But I have to speak to my commission's action, and right now we have a denial. I'm always willing to work with applicants and property owners to resolve issues. At the moment, I don't know how to move this forward without going back to the commission and without having some change to the proposal. I'm willing to work. I don't want to rip this down either, but I don't know the way forward short of that, or altering it, or somehow offering a proposal that meets the commission's objections. So that's where I am right now.
Okay, ask you this question, because you have as one of your bullet points that you were willing to work with the applicant to explore the appropriate options of modifier design. Does that mean that you guys actually started to try to work on a compromise here and it just didn't work out, or?
Well, we did explore. We did explore the artistic option, which would have either added graphics or lighting or modified the awning to add more visual interest to this facade. And maybe that would satisfy the commission. What the applicant came up with were just graphic additions to the deck of the awning, and the commission didn't feel that went far enough. So we have explored at least those options, but I don't know that we've gone far enough to really look at this creatively, and I think that's what it's going to take.
Yeah, I mean, it's in my mind, is it the color red? Is that it? I mean, plays off their logo. I mean, that's one thing I notice when I look at it. But I mean, the interesting lighting outlining the awning with red. Did you guys look at stuff like that, or?
I think those are all things that we could look at. Although the commission has said they didn't like the proposal we saw earlier this year. I don't think it's about the color. I don't think it's about whether this color is better than that color. It's about how do we make this awning appear less massive, less out of scale. I think it's going to require a creative effort to really alter it, whether that's visually or physically, and that should be our goal. But right now,
Madam Chair, I don't know, Don's kind of going out at me there.
Madam Chairman, can I speak? This is Fred Bidwell.
Fred, I just have one last, excuse me, Fred. Let me just put this in there before you speak, if you don't mind.
Oh, sure.
What I'm thinking here is, we have been in a position a couple times in the not too distant past where we have done something like remanded the issue back to the appropriate, in this case, it would be the Landmarks Commission, and asked the owner to engage in a process that could hopefully deliver the compromise solution that we're all looking for.
Thank you.
Just plant that seed.
Tim.
Mr.
Thank
Bidwell,
you,
go
Tim.
ahead.
Hi, my name is Fred Bidwell. I'm the owner of Transformer Station, which is catty corner to the property, and I'm also the developer of the Van Roy building, which is catty corner to the north, and also a resident in the Van Roy building. So I have.
Have you sworn in, Fred? Fred, have you been sworn in?
I did swear in. You may not have caught that. I can do it again.
Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, Fred, go right ahead. I'm sorry.
No problem. I run creative businesses here in the neighborhood. I've been part of the revitalization of the neighborhood, and obviously I'm looking at this property every day, walking by it every day. And this conversation strikes me as a bit of a solution in search of a problem. There have been no complaints about this awning. It's a successful business. It's a necessary business in the neighborhood. And the idea of re-engineering this awning to accommodate a process which was admittedly flawed seems like a terrible waste of private and public time. I cannot speak to the legal obligations of this board, but I think it would be a real tragedy to make modifications here. This is a successful business. It's a good neighbor. And frankly, I think although the design opinions are very subjective to my eye, and I think it's a pretty practiced eye, this is an appropriate and successful design solution, and it should stay.
Thank you, Fred.
Madam Chair, this is
Liz
Kukla again. I think we have Lori Wagner on the phone now.
Oh, okay. Miss Wagner? Sure we do.
Oh, maybe not. I thought I saw her number there.
Okay.
So I guess the question again is, can the board acknowledge that Landmarks has not done anything arbitrary and capricious, but can we alter the decision and allow the awning? That would be the question for Lori.
Madam Chair, I think Lori is on the call. Lori?
I am on.
There we
Can
go.
you hear me?
Yes, you were
Can you
muted
hear me?
before.
Okay, yes, ask her again, Liz, because I want to hear that answer.
Can you hear me? Am I muted?
No, you're here. Go ahead.
Okay, that's what I'm trying to answer that question. And as I said before, I think in this context, the legal standard you're following on this particular set of facts is not so much whether Landmarks Commission is arbitrary or capricious, but you're acting as a review board to determine whether the evidence as a whole supports their determination that the awning not be allowed. So you're making your own judgment on that point.
Well, go back to what Mrs. Kukla proposed, because I'm kind of leaning that way. I would like to see us not judge the Landmarks decision, but then offer the suggestion that Liz had made was that we grant that this be acceptable and drop this so that it doesn't keep coming back and forth.
You do have that authority to do that.
Oh.
I mean, that's what I'm saying. You're reviewing all the evidence here, and you do have the authority, legal authority, if you choose to exercise it, to say that we don't think the evidence supports this decision, and therefore we're reversing it and allowing the condition to continue.
Wait a minute. But I don't want to say anything negative about the Landmarks Commission. They were not arbitrary, capricious, et cetera, et cetera.
As I said, there's different standards depending on what posture a case is in court. And you don't have to find the Landmarks Commission arbitrary and capricious. An additional part of this, the standard is the decision supported by the weight of the evidence? And the board is acting as a reviewing body and making its own judgment as to whether it was or it wasn't. Based on what it's hearing today, does the board think it's appropriate to allow this or not?
Madam Chair, this is Liz Kukla. It's similar to the waste collection hearings that we have, where we acknowledge that the city did not do anything that was illegal or arbitrary, but then we often adjust the fee that's been issued to the property owner. I wonder if that's similar to what we can do here, where we acknowledge that the Landmarks Commission was not arbitrary and did not do anything illegal, but we find good evidence that there's a reason to overturn the decision. And we can make those comments. We can make those comments part of the resolution, of course.
Yes.
The board can do that. I can't tell you what to do, but you do have the legal authority to do that, and that's a good analogy as far as what we're doing here.
Yes. Okay. Board members? Tim? Tim, you didn't leave.
I'm going to yoga class here.
Oh.
Getting to twist our minds and bodies around our obligations as what used to be a body that just tried to determine variances.
Oh, just meditate, Tim.
How long? What's the life cycle of that awning, anyways? Anybody know?
Alana, any comments?
I think it makes sense to allow the awning to remain for the time being. I would like to have it reconsidered in, let's say 18 to 30 months, and when we're hopefully post-COVID. As to the awning itself, Mr. Zimmerman, who was the contractor for the awning, Mr. Zimmerman? Do we still have Mr. Zimmerman on?
Hey, sorry, can you hear me?
Yes.
I didn't realize I was still on mute. I don't know. I'd have to dig it up for you. It was 4 years ago now.
Okay. He's going to send it to us. Thank you.
Do you know the lifespan of that awning?
The lifespan?
I will.
Longer than it's been there right now.
It's been there 3 years.
It is a fabric. There's definitely going to be a time where it has to be replaced. I want to say the delta's 5 to 10, but I don't know exactly.
Right.
Would you be open at that time to reconsider the design color of the awning?
Yeah, happy to. Especially if it's just color. That's easy. Taking the whole thing down, we're back to square one again. I mean, this awning costs upwards of $80,000 by the time it's all said and done.
Yeah.
Right.
And by the way, it's not to say that would be the conclusion. It would be a review of.
Yeah, happy to do that.
Okay.
Tim, based on my personal experience, I put Sunbrella fabric awnings up on my house. I had it done by the top fabricator in the city, and they were up for 10 years, and the first one failed at 8 years and the second one failed at 10 years. So if they've already been up for 4 years, the life expectancy on these, given they're solid black and they're constantly out in the weather like this, I think is going to be time limited. So I think in all fairness, allow them to leave them up, reconsider when we're post-COVID, like I said, in 18 to 30 months. That's my thought.
Okay. I'll entertain a motion. I think we've come up to some reasonable conclusions.
Okay.
Go ahead, Tim.
Given the testimony today, we do not find the Landmarks Commission to be arbitrary or capricious in their review and determination on this issue. At the same time, we recognize that under undue circumstances, that we in the world are facing. And the fact that in the end, it's a design issue that probably is pretty close to, it'd be like a 50-50 vote if you went out there and talked to people about it. So it's not of urgency. It's not something that is going to make or break the design and the feel of the environment there, the character of the neighborhood, as we would say. So given all that, there's an agreement to allow the awning to stand and stay as is. Then when it is replaced, there will be a re-engagement of the design to basically assess whether or not it needs a new design or whether it'll stay the same. And it'll be an interaction that will involve both the Landmarks Commission of the City of Cleveland and the owner of Saucy Brewery.
I'll second that. Call the roll.
Madam Chair?
Yes.
I would include in the motion that it's not only the owner of Saucy Brewery, but the owner of the building.
Okay, go ahead.
It's very good. Thank you. Call the roll.
And Madam Chair, do we want to put a specific date, perhaps 6 years, or are we just going to leave it as when it fails that the appellant needs to get a new permit?
Because you don't know what's going to last, you know,
Madam Chair, Tom Vanover here. I would ask for a date certain, whether it be not necessarily tied to a fail date, but post-COVID, as Ms. Wagner said. Ultimately, I will be responsible for doing the review, and it's going to. If we tie it to the fail date, then it's going to end up with another arbitrary condition where somebody's saying it's failing and the owner's saying no, it's fine. So if we want to put a 36-month date certain on it when it comes to the enforcement part, and this is very self-serving, but when it comes to the enforcement part, at least we have a solid time to do that.
Madam Chair, couldn't you just phrase it in terms of if and when the awning is replaced, it will need to go through a new review process? I mean,
and that's something that we do. We do that at Building and Housing often with
right. I think it would just make it clear for the record that you're not approving that they can replace this exact awning when necessary as is, but that they have to go through a new review process.
I like that wording better, Ms. Wagner. Would you like to make that an addendum to Tim's motion? No, you can't make a motion. You can't do that.
I can't make a motion.
She could recommend language to us.
Yeah,
and we
you
could
could
adopt it.
yeah. Tim, do you accept her recommended
Yes.
language? Okay, thank you very much. Call the roll.
All right, Madam Chair. Ms. Barnes?
Side with the city.
Ms. Barnes?
That would be a
With
yes,
the
Ms. Burns.
city.
That would be
no.
a yes.
That's
Yes.
a no.
Oh, Ms. Barnes is a no. All right, Mr. Donovan?
Yes.
Ms. Bates?
Yes.
Mr. Johnson?
Yes.
Calendar 20-60 is approved. The decision of the Landmarks Commission has been overturned. We will ratify this case next week and send out a letter.
Thank you all. Thank you all.
Thank you for your time and consideration.
Thank you. Appreciate it.
We appreciate it.
Thank you. Okay, go to the old business.
Without objection.
Okay, old,
Hold on, I'm getting there.
okay.
There we go.
Okay. 1, 2, 3, and 5 without objection.
Without objection.
Okay.
Without objection.
Without objection.
Okay, and we need a reinstatement on East 185th.
Without objection.
Wait a minute, he didn't know. He didn't come. So you had a family emergency. Oh, please, do we? Fine, without objection. We've already handled. It isn't worth the fight. West 57th, we already handled.
We have that under handling, yeah.
Yes. Now we have to put it back on the record. Oh, hold on.
Yes, Madam Chair, I guess we just need to hear on the record that the board does not object to reinstating this.
Okay.
Officially, we need to do that on the record, that the new date will be October 26th.
Okay.
Without objection.
Without objection on calendar 20-131, we will reinstate it and hear it again on October 26th. We got that real fast.
And Madam Chair, regarding the upcoming postponement, I was unable to meet the 19th deadline. I'd forgotten that the city record was posted on Friday. So I'm not going to give it the October 19th date, but we'll put it on the 26th.
Okay.
Without objection.
Without objection.
Without objection.
All right.
And you're going to remove Kelly's name on the resolutions.
Yes, thank you. I'm sorry I missed that. I will do that
Okay.
tomorrow when I'm in the office.
Okay. Thank you. Thank you. Thank you. Everybody.
All right, everyone.
Lauren, did you drop off for a while there?
Are we done?
Yeah, I don't
Yes.
know why. My call was cut off. And I
Okay.
had to redial in.
We
Goodbye,
were looking
Tim.
for you, and all of a sudden you were gone.
Yeah,
Bye,
no,
Tim. Bye, Alana. Bye, Liz.
Bye,
Bye,
everyone.
Maureen.
Bye, everyone.
Bye, Marlene. Have a great week, everybody.